Good afternoon, everyone. My name is Caitlin Teep. I'm an attorney here at Maryland Volunteer Lawyer Service, and I also have Andrea Marson, a colleague, here with me. We are delighted to present Megan Rusciano for today's third Thursday presentation. It is going to be about supported decision-making, an alternative to guardianship. Just a little bit about Megan. She's the co-managing attorney of the Developmental Disabilities Healthcare and Victims of Crime Unit at Disability Rights Maryland, DRM, which is Maryland's federally designated protection and advocacy agency for people with disabilities. She currently chairs the Maryland's Cross-Disability Supported Decision-Making Coalition. She's also the member of Maryland's Judiciary Guardianship and Vulnerable Adult Workgroup, and she serves as faculty for Guardianship Attorney Training. So she is the expert here, and we're so happy she's here. She's also published on various disability rights topics, including forcible medication, equal access to information and communication, and segregation in prisons, which is forthcoming. So we're so excited that she's here. We do have the chat box to the right if you all have any questions. Otherwise, we will make sure that we leave time at the end for any questions that people have. Andrea, anything else? All right, so I will hand it over to Megan. Thank you.
So hi, everybody. Thanks so much to MVLS for having me today. I'm so thrilled to be able to talk to you all about supported decision-making. It's a topic that's near and dear to my heart and a lot of the work that we do at Disability Rights Maryland. I know Caitlin gave a little bit of an overview in my introduction about what DRM is. For folks who don't know us, we are, as she mentioned, Maryland's federally designated protection and advocacy agency for people with disabilities. We serve people across disabilities. So while I work primarily with folks with intellectual and developmental disabilities, we serve older adults, we serve people with mental illness, we serve people with traumatic brain injury, physical disabilities, kind of across the board. We provide supports and legal services in a number of different areas, including access to Medicaid services, which is a lot of what I work on, and housing issues, as well as special education, Social Security benefits, and other areas as well. So I'm here today to talk to you about supported decision-making, and that's really an area that we do work on across disabilities as well. So this is my disclaimer that I am always required to put on. This is not legal advice. So a little bit of an overview of what we're gonna talk about today. I'm gonna assume that folks may have heard something about supported decision-making, but that majority of folks maybe haven't. And regardless if you've heard about it before, it's good to have a common definition about what it is. So I'm going to talk a little bit about kind of laying the foundation for that. I'm going to go over a hypothetical, talk about what supported decision-making is, talk about how it works in practice, why it's important, what are some common concerns that we usually hear about it, provide some takeaways, and some resources, and then of course answer your questions. So I will get started by laying the foundation. So I'm going to start with a hypothetical to kind of contextualize this. It's my loose take on the Golden Girls. You have Sophia, who's a 70-year-old woman who recently had a stroke. She currently resides in a nursing facility, but is ready for discharge. In this hypothetical, she needs assistance with certain activities of daily living, like bathing and grooming herself, and she also has aphasia and is learning to communicate through assistive technology and pictures. She's lived her whole life in Baltimore and liked to stay there, and she has a trusted group of longtime friends who indicated that they want to help her find a way to stay in Baltimore. And one of her close friends, Rose, regularly visits her twice a week and always makes her laugh and smile. Sophia's niece lives in Cumberland, and she wants to petition for guardianship over Sophia and move her closer to herself in Cumberland. So thinking about how supported decision-making can help Sophia in this context. But first we need to understand what supported decision-making is. So before I talk about supported decision-making, I usually like to talk about the idea of capacity. And capacity refers to somebody's ability to understand and make and communicate a decision. It's their decision-making ability, oftentimes framed as an ability to indicate a will or a preference and act on it. And it exists on a spectrum, depending on the person, the context, and the nature of the decision. And regardless of who you are, most of your decisions and most of your, most decisions that you make occur on this spectrum of needing more or less support. So I always say some decisions I need less support for, like what I want to wear or what I want for dinner, right? Those are pretty clear decisions that I can make in my head. Some decisions I need more support for, though. I usually say here, definitely in my life, financial decision making, thinking through things like buying a car, buying a house. I ask a series of my partner, my family to give me input about, what is this mortgage process? How much money should I take out? What am I qualified for? What do you think of this, car that I'm about to buy? What do you think of this house that I'm thinking of buying in this area? Right? I don't make any of those decisions in a vacuum. I make them through really learning to and relying on support to the support of my friends and family to make those decisions. And some things are in the middle. So it may be a matter of what kind of job or what profession I want to go into, or something related to where I want to live. Maybe I don't need as much support with that as I do a financial decision, but somewhere in the middle. So it's important to remember capacity exists across that spectrum, and that capacity is different than legal capacity. So legal capacity is the legal principle that determines what decisions a person can make under law. So whether the person has the legal capacity to do things like sign a contract. Can I sign for that loan? Do I understand what the contract says? Can I give consent? Can I give consent for medical treatment? Do I understand the consequences of the treatment that's being proposed? That's a different question, right, than do I have general capacity? It's a legal construct. It's a legal term. And if a person has legal capacity, then their decisions are recognized under law. Everybody's presumed to have it, but if a person lacks it, they may be susceptible to guardianship. And in this, it's important to remember, right, that a person can lack legal capacity to make certain decisions, but not others. Maybe clearest with that for my clients and the people that I work with is maybe very, able to make decisions about the supports or services they want, how they want their day structured, but less able to understand larger financial implications, transactions, those kinds of things. But it's critical, they still have that legal capacity to make certain decisions. So it is granular. It's not an all or nothing. It occurs on a spectrum as well. And we kind of can't talk about supported decision-making without talking about guardianship, since it's an alternative to guardianship. So we know the standards for guardianship in Maryland, for guardian of the person, person has to lack sufficient understanding or capacity to make or communicate responsible decisions. Critically, must be due to disability. So I always pause here and say, as a person who doesn't identify as a person with a disability, I can make any kind of bad decision that I want, and no one can threaten me with guardianship unless I have a disability, right? And that's what's critical to remember when we're thinking about guardianship. And it's really entwined with the concept of dignity of risk, is understanding that, right, people with disabilities can make the same decisions that somebody without a disability can make, but they can be vulnerable to guardianship because of the mere fact that they have a disability. Also in Maryland law, less restrictive alternatives must be considered before guardianship of the person can be implemented and established. Not the same for guardianship of the property, but generally the same standard. It has to be due to a disability. Person has to be unable to manage their affairs. So it's critical, that we remember that point, that less restrictive alternatives need to be considered before guardianship is kind of pursued. And one of those less restrictive alternatives is supported decision-making. So supported decision-making is an alternative to guardianship that allows a person to keep their decision-making authority without appointing any substitute decision-maker. So without appointing an agent under a power of attorney, without appointing a guardian, they keep their right to make their own decisions. And sometimes framed as a reasonable accommodation under the Americans with Disabilities Act. It can be a matter of needing a support person present to help them understand that decision. That can be an accommodation under the ADA. So how does that kind of work? How does supported decision-making, what does that definition really mean? So people under supported decision-making use trusted friends and family members and professionals to help them understand the situations and choices they face so they can make their own decisions. It can be a means for increasing self-determination, encouraging and empowering people to make their own decisions about their lives. So basically, right, that's talking about the way any of us make decisions, right? What I described in talking to my family, my partner about making financial decisions, about buying a house, that's supported decision-making. I'm looking at a team of people, I'm contacting them, I'm getting advice, I'm getting feedback, but I'm making the decision about how I proceed. And I'm not appointing one of them to make a decision for me, right? I just rely on that support. And we legalize that support, right? So in understanding what supported decision-making is, it's helpful to understand what it's not. It's not substitute decision-making, not somebody my supporter making a decision for me. It's not my partner saying, you are buying this house, we're signing the document. Not at all. It's not surrogate decision-making. It's not, I don't have I don't have mental capacity to make my own medical decisions, so someone else is going to make them for me. Not the same as saying, with support, I can make my own medical decisions. It's not a power of attorney. The supporter does not have the authority to make a decision for a person. Appointing someone to act as your agent is not the same as designated someone to help you make decisions. And it's not shared decision-making. So shared decision-making is sometimes a term that you hear in the medical profession where doctors make decisions in consensus with their patients. So I always say there's a lot of SDMs. It's good to know the difference between them because there's several on this page. Supported decision-making focuses on the person keeping their ability to make decisions, just recognizing that they may need help to do that. So to summarize, supported decision-making kind of exists across the spectrum. You have independent decision-making, which I think is kind of a fallacy to some extent. I think that, everybody relies on some support or some feedback to make most decisions. To substitute decision-making. I mean, even if you have a person who lacks the ability to make certain decisions, you can still employ informally supported decision-making to get their input, to get their perspective. And we'll talk a little bit about that later on as well. So how does it actually work in practice? So a person can select another person or a team of people to help them think through, decide, communicate, and effectuate their decisions. And the supporter's role is to ask questions, to listen, to provide advice, to translate, and ultimately, most important role is to respect that person's decision. So I pause here just on the word translate, which is something that I think is important, especially within the disability community and even thinking through the aging community as well. People with disabilities may communicate in different ways. In the hypothetical, Sophia is learning to communicate using pictures. Some people use assistive technology to communicate. Some people need more time. Some people's speech is unclear, It doesn't mean that they can't formulate a preference or a choice. It just means that, maybe they need a supporter who is more in tune with what they're saying, to be able to translate to the doctor, or whatever professional, this is what this person is saying, or you need to give this person a bit more time, or this is the best way to approach the person. And thinking through, for older adults as well, for folks who may, have dementia, or suffer from a stroke, there may be better times in the day, right? I always say that, the people closest to you, right, they know you the best. They know how, they can tell how, if you're upset in a situation, probably before anybody else in the room can. And that's the same if, the person is, regardless of whether or not the person has a disability. But if they have a disability, maybe, as their supporter, mom does better in the morning, right? That sundown is real. And so it's better to have conversations with her in the morning. Or, this person gets really overwhelmed if you have a lot of people in the room and they're going to freeze up. Or this person communicates through gestures, and I can tell by their facial expressions whether they're happy or sad, with certain, with certain things that you're doing. So it's important for the supporter to kind of be there as a translator, to kind of translate for the person with a disability, their behavior to and their communication to a professional. Critical in this is that the person retains their right to make their own decisions. And supported decision-making is nationally and internationally recognized as a best practice, an alternative to guardianship. So how does it work in practice? I am going to attempt right now to show you I'm going to stop the share for a second, a video that goes over this. Give me 1 second. You know what? I'm just going to do it from here. Okay, let's share my screen again. Wait a second. Okay, so hopefully everybody can see this.
Supported decision-making and healthcare and medical treatment decisions. What is supported decision-making? Michael Kendra.
Supported decision-making is a way to support people so that they can make decisions by picking supporters that they trust on particular topics.
Richard Lavallo.
Supported decision-making is an alternative to guardianship, where a person with a disability can get assistance from a relative, a friend, or anyone to assist them in making decisions. And that ultimately the person with a disability makes the decision, but the supporter is someone like an advisor that helps them answer questions or provide information, but they are not the one making the decision.
Dawn and Belinda Carlton.
Well, you give the person the opportunity to make a decision.
Title screen. What is the role of the supporter? Beatrice Degree.
It's okay to have someone to support you in your decisions, that gets a little help from somebody. It could be your aunt or your mom or dad or anybody.
Michael.
Not imposing a decision on a person, but giving them as much space as possible to be the person that ultimately makes that decision in an informed way.
Thelma Green.
The supporter should remember that is the person they're working for that make the decision, not them.
Title screen. How does supported decision-making work at the doctor's office? Dr. Cynthia Peacock.
What I tell the patients is you're making the decisions, but you're just identifying somebody that's going to help you in case you have questions about what you're making a decision about. Sometimes if we're asking Beatrice, it may be complicated. And so I think Beatrice would turn to her aunt to, get some confirmation about it or get some support about how she wants to do her care. It might be a complicated procedure we might be doing, or maybe a medication we want to give her, and she'll need to talk to her aunt about that.
Beatrice.
It doesn't matter what you said. If my aunt says I can make a decision, if like people told me I have to make a decision, I'm going to make a decision.
Dr. Peacock.
We really try to facilitate, where the patient is at time and how well that they understand what we're trying to ask that they participate in. So we're participating in care plans, healthcare plans. Asking them to participate in their healthcare is giving them quality care that otherwise they may not have had in the past.
Richard.
One of the problems as an advocate is representing people with intellectual disabilities is often medical professionals and mental health professionals don't listen to people with disabilities. And they're basically just telling them what they need to do.
Dr. Peacock.
We had one young man who was given a diagnosis of cancer. He got to make the decision when, where, and how he was going to participate, when he was going to use treatments, and what his life was going to be. And I'm going to do basketball before I go get my chemotherapy.
Thelma.
I suggest that doctors and nurses should talk to the individual, the patient, the one that's coming for the help, instead talking to their support.
Dr. Peacock.
An individual with an intellectual disability sometimes can struggle in a doctor's appointment, maybe fearful of what's happening around them. Maybe they weren't given enough time to understand and to participate in the discussion and in the visit. So maybe an individual provider out there has maybe an implicit bias about that individual, thinking that they can't make a decision, and then and makes that decision maybe in a couple of minutes of the visit, and then turns to the family member or the provider that's with them.
Thelma.
The doctors and stuff need to take a step back and talk and take time to listen to the people, because everybody can't talk verbal like me or can't talk like that.
Dr. Peacock.
If someone has to sit and think about a decision and they have to confer with their family member or who they anointed as the supportive decision maker, you just may have to leave the room and let them spend time talking about it, go on and see another patient, and then come back.
Thelma.
Maybe they might have speech problem because of their cerebral palsy, or they might have a stroke or whatever that slow them down. Everything is so fast nowadays, like a computer. They need to take a step back, like typewriter age, and really listen to those who really trying to get the point across and get their voice heard in a lot of other ways.
Dr. Peacock.
Or it may be something you take home and you come back the next day or the next week. There's nothing to say that you can't see that patient again and again, 2, 3, 4 times before that decision is made. I think that that's something that providers don't really think about when it comes to, oh yeah, if you just have them come back and we can talk about it some more. They want that decision there and now, and then you can get on with whatever's going to happen.
Michael.
And there's still hard things in decision making. That support decision making, it makes a lot of it easier. There's still intrinsically some decision makers intrinsically going to be not straightforward and stressing of the person, and difficult to be sure you made the right decision.
Thelma.
Sometimes doctors look at our equipment before they look at us as a human being and a person.
Donna Belinda.
We have to give them the opportunity to be a part of the world and take chances and make mistakes and
Fall and get back up.
Beatrice.
As I get older, I have to be making decisions for my kids.
Special thanks to Don Carlson from Austin, Texas.
Okay. So hopefully that gave you a better sense of how supported decision-making can work in practice. I love Thelma's quote about slowing it down to typewriter age, about not just seeing the person's equipment. I think that, if you walk into the room and you see a person in a wheelchair or somebody who is physically not capable and relies on a lot of, durable medical equipment to support them, or even a ventilator, you're going to make an assumption on what not you, but someone could make an assumption on what they can or can't understand. And you can't look at the equipment first, right? You got to see what the person really can communicate. And as was stressed in that video, that takes time. It's something that's time intensive. And in our computer age, it's not something we have a lot of time for, but it's really an important, thing to remember. So I keep on going. Supported decision-making is, let me just make sure, yeah. So why is supported decision-making important? Well, it's recognized, as I said, as a best practice. And actually most states in the US have introduced legislation or have passed legislation recognizing supported decision-making. So legislation legalizes that relationship with a supporter rather than just having reductions of an ADA accommodation. It says, here's what a supporter is required to do. Here's what the supporter has the authority to do. And, here's what the supporter's role is. And, the person has the opportunity to select a team of people, to pick a supporter for, I always say, I'm not going to choose my brother to make healthcare decisions. I want him to help me make financial decisions. So he would be on the team for that. I, go to my mom, who was a nurse, for medical advice. It allows you to have that flexibility with your team. And critically on this list, Alaska actually passed a really innovative law that allows for supported decision-making within guardianship. So using it both as a tool to cede back authority to someone for decisions that they can make, and also to use it as a tool within guardianship to promote a person's decision-making ability, to hopefully make the guardianship less restrictive, to get them involved in making decisions, and to be in tune with what that person wants. That's really making the guardianship less restrictive. Maryland, at the bottom of the list, we did pass a narrow law recognizing supported decision-making in the context of organ donation. So people, basically people with intellectual disabilities, were being denied access to organ transplants because there was a thought that they couldn't understand the medical procedures and treatment and needed to sustain the transplant, and supported decision-making was recognized as a means to really open that door for folks and say, with support, they can understand the treatment options available to them. But we don't have a wider law in Maryland. That's something we're currently working on. So there is no existing legal tool that allows a person to select another person in supporting them in making, communicating, and effectuating decisions while still letting them keep their legal authority. So all of our legal tools sort of say, you'll get to a point in life when you can't make your own decisions. And when that happens, someone else will make a decision for you, right? That's how guardianship works. It's typically how powers of attorney work. It's how surrogate decision-making works. Nothing gets into that gray area of, I just want help, or I need somebody, I need more time. I need somebody who understands how I communicate to help me communicate my decisions to other people. There's nothing really that recognizes that, and that's how supported decision-making is different. It's important because people with disabilities are vulnerable to unnecessary guardianship. And we know from practice that guardianship is restrictive and often permanent, and that some people with disabilities end up under guardianship based on stereotypes or assumptions about their capabilities. I have seen this a lot in practice, people assuming that based on an IQ score, someone needs to be placed under guardianship based on what their I hate the term, but what their mental age is. You know, unfortunately, we live in a society that in order to access public benefits, right, people need to talk about how disabled they are. And it is a quick leap, often too quick of a leap, between meeting those standards and then turning around and saying, well, I have all this evidence that shows this person can't live independently, this person needs all this help with bathing and grooming, this person can't make all these decisions, to, well, clearly then they need a guardian. And that's not the case, right? Often actually getting access to those public benefits prevents the need for guardianship because it gets the supports in place that ensures the person isn't isolated, that they have a team around them, that they can make their own decisions. And it has nothing to do, right, with decision-making capacity. It just has to do with the disability and the nature of what their disability is. People have different ways of communicating. It doesn't mean that they cannot express their preferences or choices. I have worked with people who communicate through gestures. I have worked with people who communicate through, different types of eye gaze, facial expressions. People can still communicate. Behavior is communicating. And it's to the extent that you can understand it, right? That you have somebody there supporting that person who understands what their means of communication is. And, to the extent that it can be understood and conveyed, preferences and choices should be honored. And that's really a basic concept in a civil rights issue, because fundamentally, right, we are our choices. Try to imagine if you didn't have the right to make your own choices. We all view ourselves as a critical part of identity, from who we decide to go out with, who we decide to marry, where we decide to live, what we decide to wear, how we decide to cut our hair, right? All of those are decisions we get to make in our lives. And those decisions aren't always available to people with disabilities. They get taken away under guardianship. So to the extent that, we can see those decisions back, we should, because it's critical to a person's identity. And decision-making evolves across time. You're often looking at folks who just had an injury, maybe, and who are relearning skills. They may relearn some of those, they may relearn making better decisions. They may be able to refine their decision-making skills. Even for people with dementia, that diagnosis doesn't mean they can't understand, and you don't have to listen to what they say, right? There are times when folks are, certainly in the beginning of the diagnosis, when people definitely can continue to make their own decisions. And even to the end, I mean, people can, still have some control and some input to give about what choices, they want to make about how, their life unfolds. From the developmental disability side, I always think about the fact that a lot of people with IDD are placed under guardianship when they turn 21, age out of school, or when they turn 18, because school districts say you got to get guardianship right away. And, I always say I didn't make the greatest decisions when I was 18, and nobody threatened to put me under guardianship, right? I like to think that I make better decisions now than I did then. This decision-making is a skill, right? It's a skill you learn, and you got to be able to make some mistakes so you can learn from them. There's also plenty of data that supports people who exercise greater self-determination, have improved life outcomes. They're more likely to live independently, work in the community to higher paying jobs, be able to identify situations where they could be abused, and less likely to suffer abuse. That makes sense, right? Because if you tell somebody that their voice matters, if you're always looking to them to see what their position and their view is on a certain decision, they're going to learn that, they matter and their voice matters. And that's a really critical tool in combating abuse and neglect. Conversely, studies show people who are denied self-determination have worse life outcomes. So this is, it talks about people in overbroad guardianship having significant negative impact on their mental health, longevity, ability to function. Folks experience low self-esteem, passivity, and feelings of inadequacy and incompetency. I mean, just imagine for a minute, you go into a doctor's office and, you're sitting there with, your son or daughter, and the doctor is just looking at your son and daughter and not communicating with you at all about your own care. How does that make you feel on a fundamental level, thinking through the impact of that, and saying that this person's voice doesn't matter anymore has an incredible impact on people's lives. Supported decision making has also been endorsed by a number of organizations, the American Bar Association, the National Guardianship Association. You'll have access to these slides so you can go through, but a number of federal agencies as well. State courts have also terminated guardianship in favor of supported decision making. I've listed a couple states where that's actually happened. The U.S. Department of Health and Human Services also funds the National Resource Center for Supported Decision Making. That's also funded pilot projects on supported decision making across the country. So it's gaining traction. It's something, if you haven't heard about it, it's something that is nationally recognized and being funded across the U.S. Also, the ABA issued in 2017 a resolution on supported decision making, urging states to amend their guardianship statutes to require that supported decision making be considered as a less restrictive alternative before guardianship is pursued, and that supported decision making be considered as a means to terminate guardianship in restoration proceedings. So that's available in that link. He also came out with a tool for attorneys to encourage the use of supported decision making. It's called the Practical Tool, which is a belabored acronym, and I cannot remember what all the letters stand for at this point, but it is a great tool to walk through if you're an attorney looking at whether or not somebody needs a guardianship and whether or not alternatives are available. As I said, it's an ABA product. So back to Sophia. How can supported decision-making help her? Well, she may be able to use supported decision-making to circumvent the need for guardianship. She can use her natural support. She can draw on her circle of friends to help her advocate to remain in Baltimore. And she may be able to get home and community-based Medicaid services that help her stay in her home, or help her move to an assisted living facility. She can also use supported decision-making to help develop and refine her decision-making ability as she's recovering and learning to use assistive technology. And just because she has difficulty communicating does not mean that she does not have legal capacity to make her own decisions with support. So what are some concerns about supported decision-making? Commonly, I will hear, well, how do you protect against abuse and exploitation? Generally, as a concept, supported decision-making is about encouraging self-determination and self-advocacy. It is about, promoting those things, and that, that combats the opportunity for exploitation. Also, it's important to recognize the place for dignity of risk, thinking back at our guardianship statute, which says that you must have a disability, must not be able to make decisions because of your disability. People without disabilities can make the same decision as a person with a disability and potentially be vulnerable to guardianship. And so it's important to think critically about, what is a decision that's really tied to their disability? What is something that, it's a matter of they can make their own decisions. They need to learn the consequences of this. This is just part of the natural effect of, growing and learning to make better decisions. So in supported decision-making, you can set the scope and execution of supported decision-making arrangements and agreements to say that a person, a supporter can't unduly influence a person. Here's what a supporter's responsibilities are. You can think about using monitors, people to supervise generally supported decision-making agreements. But ultimately, probably the biggest way to prevent abuse and exploitation is through the fact that a supporter has no authority to make decisions for a person, right? a supporter can't go into a bank and take out all of a person's money because they don't have the legal authority to do that. Only the individual does. And if there's really a concern about undue influence or abuse, then the bank can look at that objectively and say, I think that this is a case of undue influence. So there are natural ways to kind of protect against abuse. What if somebody doesn't have any natural supports? What if they don't have a supporter in their life? Right, in Maryland, there is a advisory letter on our surrogate decision-making law that indicates that in certain situations, paid staff may qualify as a friend in our surrogate decision-making statute if they meet certain criteria, if they are an actual friend. Think about that. I mean, that happens a lot with people with intellectual and developmental disabilities who may have been in services for a long time. It's their caregivers who they're closest to. There may be ways to consider supported decision-making in that role. Like I said, because the supporter's not making decisions for a person, it's less of a conflict, right? It's less of, you're just helping somebody understand the consequences, which is part of, your job as a supports planner or a coordinator of community service. And some jurisdictions have considered volunteer supporter programs as well. So some takeaways, people communicate and express preferences in different ways. Doesn't mean that they don't have legal capacity and can't make their own decisions with support. Everyone uses supported decision-making regardless of disability. It is not a matter of, just this is only a concept that applies to people without or with disabilities. It's important to remember this is how we all make decisions and to normalize the relationship around it. I did work in British Columbia, Canada before I came to DRM, and which is the first jurisdiction in the world to pass a supported decision-making law. And there, everybody in the organization that I worked for who, regardless of whether or not they had a disability, they had a supported decision-making agreement, because it is just it's a good model, right? Even when you sign a power of attorney, I pause and I look at all the authority that I'm giving someone, and I'm like, well, what if I just want your help? What's the line there? And so it really is something that I think can benefit our entire community, regardless of whether or not you have a disability. And just remember, again, supported decision-making, supporter's job to ask questions, to listen, to give advice, and to ultimately respect the person's decision. Recognizing that sometimes people make bad decisions, but it doesn't mean that they don't have capacity. So what can you do in practice? Presume capacity. We're legally required to anyway, but just remember, because it's easier, as Felma said, to see somebody's equipment before you see them. Recognize that that's a bias. That's, the ADA is 30 years old, but the State Institution for People with IDD in Maryland just closed in 2010, 10 years ago. So there really is a legacy of discrimination that lives on. Recognize the place for dignity of risk. Recognize some people make bad decisions. It's part of life. You try to keep people as safe as you can, but recognize that there is a role to kind of push the box a little bit. Maryland law requires consideration of less restrictive alternatives. So remember that in guardianship proceedings. Try to use the ABA practical tool when you can. There's also a model rule that contemplates supported decision-making. So the professional rules of responsibility for attorneys, 1.14 for clients in diminished capacity, comment 3, it talks about family members or friends wanting to participate in discussions with the lawyer, and the person, the presence of that person doesn't waive attorney-client evidentiary privilege. So that's really critical. The supporter needs to be in there with a person. And just recognize in practice ways you can make communication more effective. recognize the role in informal or formal supports, the role of peer support, the use of technology, and really creating warm and respectful environments for people as well. And then I have a list of resources that you will be able to see. I'm going to just scroll through the MVLS slides as well, so I can start taking questions if folks would like as well.
Hi, Megan. I just want to thank you for that presentation. One just big takeaway for me is that when you talked to, when one of the people in the video was talking about how it may take a few sessions to when you're meeting with a client to for them to come to a decision. That happened in a recent case of mine. And I think the co-counsel that's been working with me on the case, volunteer through MVLS, is a little frustrated because the longer this client takes to make the decision, you know, it impacts the case somewhat, but it just was really important. She depends on people in the church to help her make decisions. And that's really, really important to her. And I don't think she'll feel as confident in any decision without the counsel of those trusted people. So in that case, that is more important than the case outcome in a certain respect.
That's a great example of how you can use supportive decision making and how people use it generally.
So Caitlin had an interesting question. We were talking earlier about often it seems that in the guardianship cases MVLS takes, people don't have anyone at all. They don't have the trusted friend or clergy member. So do you have any advice or rules of thumb in cases like that where someone doesn't have a big circle?
So yeah, I think, you know, in those situations, it's always hard. I always say it may be that a person may have, you know, if you do some digging, being a supporter isn't being an agent. It's not as onerous. It's not a responsibility that's, you know, you're you know, required to take control of this person's finances or make all medical decisions for them. It's a matter of just helping somebody understand what the consequences are. Sometimes, as I said, a person, excuse me, with, you know, might have support staff in some way, professionals who may be helping them. That may be, you know, assuming that it's not on the same service that they're requesting, you know, if they're talking about something general, they may be able to provide support. Also going back and just looking at a person's history and again thinking, excuse me, if that person didn't want, you know, if there's you know, someone in their life who's concerned about all the roles and responsibilities of a power of attorney, maybe they're more willing to step up. You know, I had a case where a person didn't have anybody in a nursing home, and actually eventually the family, he shared the room with another patient, and the family of that other patient offered to be a supporter for him because that family was there pretty regularly. And so, you know, really this is about fostering community, which is a whole nother thing outside of the legal profession, but looking for those connections and kind of having an eye out, I would say.
That's a great question or answer. We have some more questions in the chat I just want to make sure we get to. I think a good jumping off point from that, if we are talking about the paid supporter, the paid you know, nursing staff surrounding someone without a lot of family and friend help, what additional protections and safeguards exist in reference to using paid support staff as a supporter?
Right. So, I mean, currently Maryland doesn't have a supported decision-making statute. So we don't formally recognize supported decision-making. There aren't, you know, so the only thing we can kind of cling to is going to be the ADA in a way. And there are going to be those conflicts. So I would say at this juncture, unfortunately, I don't think you would be able to draw upon paid support staff unless directly, if it's on issue directly with, the service that's being provided. So in the nursing facility, if it's about discharge, I can't imagine that it's probably a conflict. But I think that in different settings, you might have, the ability to kind of use those, those kinds of supports. And I think that as we look at developing a law, something that we're hoping is, in those situations, you might be required to have 2 supporters instead of just 1. As a safeguard, you might be required to have a monitor, somebody maybe like a supports planner who oversees the agreement, makes sure that there's not, abuse. So those are the kinds of things that we're thinking about as we're looking towards legislation. But at this time, I don't, it's something that's tough because it's not legally defined in law, and there's a ton of conflicts that exist. So it probably would be ethically a little sticky to pick a paid, staff at this juncture.
That's a great point. So a commenter in the chat asked, how can you convince attorneys that file guardianship petitions to conduct the preliminary work to try and determine if there's a less restrictive alternative before filing the petition?
This is a great question, right? Because, I think that I've had, the most trouble in talking with a lot of attorneys who handle elder law and kind of understanding what supported decision-making is. And I think it can be tough, but you do have that obligation. You are going to have to go before a judge and say what less restrictive alternatives were considered. And that is something that you have to check off on the certificate of incapacity that the medical professional has to. So, I think that, and I'm presenting actually next month with a judge, a former judge, Judge Karen Jensen, and a self-advocate at the Pro Bono Resource Center on supported decision-making. And Judge Jensen has shared regularly how much the bench, really there is a push because of the flood of guardianship petitions to consider less restrictive alternatives. That is just the reality of the aging population. We all know this, but, basically I think it's a matter of, depending on your judge, you would end up with a lot better of an outcome if you do your prep work. And you are legally, you have to answer to that standard, right? You have to answer to say what less restrictive alternatives were considered. And, STM is considered informally. You don't have to call it supported decision-making. You can just say, a person needs to have, this person to help them make decisions. It's a reasonable accommodation, and that's a less restrictive alternative. Maybe have them sign a power of attorney, use it in conjunction or an advanced medical directive. See if they can, use it as a tool. But I think that part of really convincing the attorneys is, one, doing a lot of work on stigma and historically changing perceptions about people with disabilities, but also in a blatant way, just saying this is legally what you have to consider before you go into the courtroom.
So more pressure from judges could create a better obligation to really do that due diligence.
And there is the Judiciary's, which I'm a part of, the Judiciary's Guardianship and Vulnerable Adult Workgroup had made recommendations to promote alternatives to guardianship. Excuse me, it's happened once before. Or I have like a choking attack at the end of a recording, but they're actually looking to come out with some videos on alternatives to guardianship as well. So they're really, the Judiciary really, I think, is pushing to see, more mediation, more consideration of alternatives. I think is where we're moving.
We have a question that I wonder if it depends on what state you're in, the answer to this question. So someone asks, how do we determine if someone is engaging in the process of supported decision-making if there isn't a written agreement? Do we need to distinguish between people consulting with family versus quote unquote supported decision-making?
So it does, that's very true. It does depend on your state. So supported decision-making, there's a lot of talk among advocates whether or not you even need a law, because it can be that simple as just talking with family. And why do we need a law to recognize that? And the only reason why you need a law, in some people's opinion, is to legitimize it and set the boundaries and restrictions, like the paid staff as a caregiver, that kind of thing. But in most cases, you know, it depends. DC has a supported decision-making law. So you can see in that case whether or not they have an agreement in place. But if not, it's just an informal tool that you can use and you can cite to. I mean, there's cases, you know, across the country that have terminated or prevented guardianship, you know, based on supported decision-making. And I should have mentioned, but in those cases, there's a case recently in Indiana, there's a case in Pennsylvania. At the time that those cases came down, those decisions came down, there were not supported decision-making laws in those states. So it was recognition of this person uses support. And it's easier to make the argument now that it is supported decision-making because it's a legally understood concept in other states and there's a bunch of data on it. You know, it's something that you can draw on in a brief and say, here's a nationally recognized practice, this is what this is. And the court can, I mean, the court has plenty of statutory authority to carve out that type of agreement, right? To say, okay, we're going to terminate the guardianship, or we're going to, you know, I'm not going to impose a guardianship. I think we can do a supported decision-making agreement, and then the court can craft it, right? So you don't necessarily have to, you know, you'll want to, if you're in a jurisdiction that's passed a supported decision-making law, to look for that agreement. In Maryland, you won't need it. There are ways to kind of informally recognize it. I hope that answered the question.
Yeah, so we're at 1:30, but we have one more question and then we will let you go. Thank you so much. So one of our attendees asks about revoking a supported decision maker. I would imagine this is less onerous a process than challenging guardianship, but could you speak to that concept?
Yeah, so I mean, the idea is, I mean, informally, right? There's no formal recognition right now in Maryland. Technically, you could sign an agreement. It would have the weight of a contract, but whether it's legally enforceable is, you know, it's always a tough question. So typically, right, in states that have passed legislation recognizing supported decision-making and that have actual agreements, it's as simple as revoking, you know, a power of attorney. You just have to write and set notice to the person that you're revoking, or tear it up. And I would argue that creating a supported decision-making agreement requires a lower level of mental capacity than something like a power of attorney, because you're not saying this person suddenly has the authority to make all these decisions for me. You're just saying, I want this person in the room. It's easy to say, now I do not want this person, right? That's a much easier decision for you to make than I don't want this person to have access to my bank and trust and all my stocks. And it's much more complicated, right? And revoking a POA. So it's meant to be a straightforward process. That's what we're hoping. We get a law passed in Maryland, that it will be something that's simple, just a matter of notice and revocation, or you can sign a new one and have it change. And that's kind of the idea, right? Is that it would evolve, especially as people grow and age, just like you're hopefully going to update your will, and you're going to, you know, as you have kids, or as, you know, your life changes, it's just part of, you know, who you have in your circle of support. So the hope is that it's pretty easy to change. But informally, you know, if you're just recognizing it, you know, I've had plenty of situations with clients who, you know, the intake call comes in and it's from a mother, and I talk to the client. The client's like, I don't want you to talk to my mom. I want you to talk to this other person. And it's maybe, you know, I have this other person that I like want involved in the conversation now. And so it's just part of, you know, letting them guide the ship, really, in that way. So it can be more informal is what I mean when there's no formal actual agreement.
And that just sounds like another virtue of this concept. So gosh, well, thank you so much, Megan. That was so informative. I really hope that Maryland gets his act together and passes this soon, so it can be enshrined in our guardianship proceedings and be a viable alternative to guardianship.
One more final plug. We started a coalition in Maryland that's looking into supported decision making as the alternative. I'm really trying to educate folks about it. And one of the goals is to hopefully next session be looking at passing legislation. So if you have any interest in learning more about supported decision making, want to be more about the project, want to pepper me with all your doubts about it, I am happy. I will talk to anybody about supported decision making, whatever concerns you have, because I really do believe it's a great tool that can help us limit the number of guardianships that we see, and also just give people their voice back. It's a little more work, but I think it's definitely worth it. So,
but it's worth it. Well, thanks again. 2022, look out, Maryland. We're going to have this on the books. Thank you again, everyone. Look out for an email from me with this PowerPoint, which also includes Megan's contact info. So you can indeed pepper her with any questions or comments. And hope you have a great day. Thanks.
Thank you all so much.